Good morning and welcome to the Child Welfare Law Advanced Institute Multidisciplinary Training, Case Planning, Risk Assessment, Case Review Systems, and Judicial Expectations. That's quite a title, isn't it? The Louisiana CASA Association, local CASA programs, and the Court Improvement Program partner together to bring you these trainings. The CIP program, the Court Improvement Program's mission is to improve case outcomes for abused and neglected children by enhancing the quality of legal services that they receive. And one way that they do that is through multidisciplinary training such as this. Our first speaker this morning is Judge Joy Labrano, and she's with the 25th JDC, and I'm going to go ahead and not prolong this with a huge long introduction. Let her come on up and do her presentation for us this morning. She's going to be speaking about the judicial expectations, what she needs from the bench, from all of you folks, the folks who are providing the information that she needs to make the decisions for the children that are in care. Judge Labrano, thank you very much for joining us today.
Well, good morning. My name is Judge Labrano. I am a very young judge, baby judge. I've only been a judge since January 1st, 2009. But somehow I have been asked to speak almost 3 to 5 times. So I'm not sure if they were very excited what I did in the DA's office for the last 12 years or that they say a sucker. Because I used to, as a assistant district attorney, I spoke a lot at the LDA conferences, and I enjoy that. And in Plaquemines Parish, I was able to implement a lot of programs in the parish, and so I never know why I have been so asked to be on committees, to be involved in speaking, but I think it's a wonderful thing, and I think it's very, very important for judges to come out and speak to the people who are in their court. One thing I'm going to try to accomplish today is to let you kind of understand what's going on in my mind. You know, when you walk into the courtroom, there's the judge, and as we know, there's many, many different type of judges. I have learned that in the last year and a half. However, we all have some of the same rules. We all have some of the same expectation. But you may have an idea as to what type of judge you're in front of, especially ones who you practiced before them for a very long time. Now, you should know about your judge. I'm a judge who came from the district attorney's office. I was the first assistant district attorney in Plaquemines Parish. I was chief of the special victims unit where I worked with domestic violence, child abuse. I was also an assistant district attorney who was very active in the community, implementing school programs. So you can kind of start understanding the philosophy of a judge by looking at where they came from, how long they've been on the bench, how much have they been involved in juvenile matters, because I'm a district court judge, and I realize there's a big difference between a district court judge doing their juvenile docket and a judge who's a juvenile judge, and that is their jurisdiction. That's what they do. So it's a very different, I found there's very different ways that juvenile courts and juvenile days are handled. So get to know your judge. Like I said, I am one that's very new. However, I have a lot of opinions. I have a lot of opinions because I do think I see the big picture. Because I did come from the district attorney's office, and also I was very involved in funding, in working with service providers, working with funding providers, and working with the juvenile justice system. Now, actually, when I was in the DA's office, I was more involved in felonies and misdemeanors. I did not work juvenile except when our juvenile assistant district attorney needed someone, she was out for the day. So this is all relatively new to me, but at the district attorney's office, I learned about teamwork. I learned about stakeholder meetings. For me to develop a domestic violence program in Plaquemines Parish, I knew I needed every agency. I needed every agency to participate. I needed every agency to understand what hat they wore. I needed every agency to know that we were all moving forward to the same goal. So with that in mind, think of what a juvenile court judge. We are supposed to fairly and impartially decide cases, administer justice. Fact finders. That's easy. See that? Now let's look at this down here. Now I start putting a lot on my shoulders, and now I'm getting very concerned. What are the goals? And I just use SING cases because, you know, with delinquency, there's a lot of victims involved. FINS is more early intervention. So I tried, because I would have a holistic goal for each of those types of cases. But because this is concentrating on child in need of care cases, look at the goals. Now remember, judges take these goals very serious. We can look at cases, decide what the facts are, and then decide, administer justice. But this is important: protecting children, strengthening families, providing permanency for children, assisting children to reach their full potential. Now look at this one: delivering comprehensive services to children and families. That's big. Assisting families and the community to function in the best interests of children. That's big. That's big. And I'm going to show you how hard it is to accomplish these goals, and the only way you can do it if all the stakeholders are able to work together and understand their role. And there's another thing that happens to judges. We go to a lot of seminars. The Supreme Court provides wonderful education for judges. So we have gone to the seminars that tell us about child abuse, child neglect, and we know about the statistics. And I want to go through them so you know what's in a judge's mind. If a judge gets upset because they're not happy with your testimony or they're not happy with the progress of a case, it's because we know the statistics. We know why we're here, what we're here for. We're here to protect the children. And I know you've probably seen these statistics, but I think we should go over them again. Every 6 hours, a child dies in the United States due to abuse or neglect. That's 4 children a day. In 2005, more than 3.5 million children were reported as victims of child abuse or neglect. Child abuse kills more children in America than accidental falls, choking on food, suffocation, or fires in a house. It is a heartbreaking tale. In 2005, almost 1,500 children died from abuse or neglect. 80% of these losses were children aged 4 or younger, with infants under 1 of age the most common fatality. Another almost 900,000 children were victims of abuse or neglect. And I'm going to go through these, but look at these numbers. Judges know these numbers. They know this. We are trained, and they have a wonderful program for juvenile court. The Louisiana Council for Juvenile and Family Court Judges, I think one of the best programs I've ever been involved in. They give us seminars that are full of very good information, up to date, and they are working very hard to have judges to be very informed about the work you do and about the community and about the issues that we need to address. The youngest children are the most abused. Children's age 3 or younger are consistently the most victimized group. 1 in 3 to 4 girls and 1 in 6 boys have been molested by the age of 18. Boys report less than girls. 70 to 90% of molesters are family members or friends. 62% of pregnant and parenting teens were raped, molested, or sexually assaulted prior to their first pregnancy. Children have been abused or neglected, or 59% more likely to be arrested as juveniles, and 30% more likely to commit a violent crime as adults. You know what that means? That means let's catch it in SING cases when they're little. Let's get them good treatment. That's early intervention. That's something I'm an advocate of. Just remember all this, what's in my head as a judge, when I maybe will get upset when I don't like the case plan properly progressing, and I don't feel the child is getting the proper care or the parent's getting the proper rehabilitation. Just remember that. More than 8 out of 10 abused children are abused by their own parents. Fathers, stepfathers, friends, and neighbors are generally the offenders of sexual abuse. If one child in the family is abused, generally other children are abused. And we all know that child abuse is a cycle. Community awareness and prevention programs targeting at educating and retraining parents can break the cycle of abuse. Now here's just some Louisiana statistics, because it does vary throughout the United States, but a child is abused every 48 minutes in Louisiana. Once every 63 minutes, a child is confirmed neglected. Once every 3 hours and 36 minutes, a child is confirmed physically abused. Once every 10 hours and 37 minutes, a child is confirmed sexually abused. In 2006, 48 children in Louisiana died as a result of abuse and neglect. Know these statistics and know that we know them also. Another thing you need to know about judges, we're human, and we have a job just like you, and we have a boss. We have a boss. It's the Supreme Court. It's the Supreme Court, and we have a lot of rules. We have the Judicial Code of Conduct that requires me to very heighten duties of a judge regarding my administration, my office, functioning, promptness, all in my Judicial Code of Conduct. This is my standard of practice, and we're going to go over some of your standards of practice. This is it. The Supreme Court oversees judges in Louisiana to make sure they are doing their job. And I think in Louisiana, you know what happens when you don't do your job as a judge. So when I'm a young judge and I see this sheet of paper, which I enlarged on your handout, it's the Office of Judicial Administration, Supreme Court of Louisiana, report of noncompliance with statutory time limits. Supreme Court rule number, continuance and delays in child abuse and neglect cases to be submitted within 10 days of court's decision to grant continuance and permit delay. Now I'm a young judge, that makes me nervous, okay? And I'm very concerned, and we have developed our timesheet where we are very concerned about the timing of the case. So when I have a witness that's unprepared, I look at all these issues. I think of the child, how this is going to affect the child in 10 years, how it's going to affect the family, how it's going to affect my community. I'm a judge who looks at the big picture, so that's maybe why I might get upset when I can't understand why we can't get assessment of a child in time. But just know that it is something that my goal is protecting the children. And you have to always keep that in mind. So here's a judicial expectation number one. I look at everything that I have done through my domestic violence team, and I use the word now, stakeholders. We are all stakeholders in the juvenile court. We are stakeholders because we all play a very important role. One that sometimes overlaps and sometimes are very misunderstood. And I demand cooperation, coordination, and mutual respect. It is so very important and so difficult to do. When I started domestic violence team approach, it took me a while to have the sheriff's office actually work with the district attorney's office, because they were all blaming each other. Well, I don't get convicted, you don't do the right arrest. And it just went back and forth. But it went back and forth behind closed doors. So I started the meetings, and everybody started talking together. Everybody realized one thing. They were all here for the same reason, to protect the victims and to administer justice in the most efficient way. So let's talk about who are the stakeholders. Now, I divide things up in my mind as to different categories, because each of these categories have different functions. We have the juvenile justice providers, we have the service providers, and we have funding providers. And I showed someone this this PowerPoint. They said, "Why you have funding providers?" Well, I think that's very important. That's something as a judge I look at. I'm someone who also, I write grants, and I try to get funding through our local government to present different programs in my parish. So I think it's a very important reason. I'm going to show you why. Now I'm looking at the list of people who have registered. Do we have any assistant district attorneys? Good, because I can make fun of them now. And I was an assistant district attorney, so I can. I see we do have a lot of OCS workers. Can you raise your hands? I think we have about 19, yeah. Attorney for children, I think that's a large group also. How about parents? How many attorney for parents do I have? You do both? And I see OCS attorneys. We have a lot of CASA. I see a lot of CASA here. Can you raise your hand, CASA? Okay. We have some FINs? Okay. I'll address a little bit of FINs, but I was more working with SING, but it all works together. Now let's talk about our juvenile stakeholders. We have the court or parish employees. Every district does it some differently. In Plaquemines Parish, they're mostly all my court employees through the parish. We have the FINS officers, the juvenile probation officers. We have a juvenile drug court and mental health court. We have adult and family drug court. You should always know the juvenile minute clerk. Very important person and all this stakeholder. At least ours are very good. We have the district attorney's office. We also have the public defender's representation. In our district, through the PDO, we have attorneys for children through the mental health advocacy, and we have attorneys for parents. We have the sheriff's office. We have our own juvenile detectives in Plaquemines Parish. And you also have this, of course, you have the state agencies, OJJ, probation, OCS workers, attorneys, and you have CASA. Now, these are all working for delivering the juvenile justice system to get to me facts and information basically about this group right here. Service providers, we get frustrated with. And what I have found is that my poor OCS social workers, sometimes I get mad at them. Why can't you get that assessment at LSU? Why the service providers do not have space? I told you I needed that report in 30 days. It's right here. Do we have service providers here? Okay. I'm going to talk about you too. All right. Well, it's not talking. It is being realistic. It's being realistic when you come before the court and the case has not progressed like the judge wanted it to. You need to really document. Yeah, I tried to go to LSU and get this. They were so backed up. Metropolitan Human Service District, the clinic in Plaquemines is so backed up. We were not able to get an appointment on time. I want to know that. I want you to document that. I want you to have a timesheet on that. That way I can go to my funding sources, because I also do that. I can go and say, look, we are having some issues with properly getting our reports, assessments, and to getting people into any type of intensive outpatient addictive disorder, drug rehab. This is very important to a judge to know. And what I find sometimes is the poor OCS workers just sitting there saying, I called. But I want to know more information. So understand that as stakeholders, we are going to go back and forth and sometimes blame the other agency. And I think it can be done in a way that's proper. But I think it's important that the judge does understand exactly what you are going through if you cannot actually get someone in an OJJ facility on time. You know, we're all fighting for that placement, all the judges. So understand the dynamics that are going on here. And also understand dynamics with, we have a district attorney's office. And they a lot of times are in conflict with the attorneys for the parents. You know, when that mother's failing in addictive disorder in a program, what happens is the DA, you can hear termination, termination, termination. And the attorney for the parents wait, they assessed her wrong. She should have been in an intensive inpatient treatment 8 months ago when the children were removed from the home. Well, now we all know 8 months are serious. We have our timelines coming up. And what happens, I see, are the stakeholders start getting nervous about the 9th or 10th month when they realize, something went wrong. So stakeholders, it's very difficult to do, but we need to work together very early on and not point fingers as to why this case plan's not working. Why did we not get an assessment on time at LSU? Maybe, and I've seen CASA workers help OCX workers maybe get things done a little proper than normal. And one thing I suggest, and I don't know if your district has this, but if they do, attend stakeholder meetings. We have a monthly in Plaquemines Parish, and since January, it has been wonderful. We get together, and we have the Allspill, we're the parish of all the disasters, and you are too, but it helps for us to talk to all our stakeholders, the schools, and how do I go back? Do we know? The backspace? Remember, at my stakeholder meetings, I have my service providers there. Very important. I have someone from Metropolitan Human Service District. I have someone from the schools. Now, I put schools there as service providers because they are. They provide me with my 504 accommodation reports. They provide me with, because I tried very hard to get my students in FINS, who I know should be classified as a 504 student, and get the accommodations. We work with them. They are my provider. Very important, I think, aspect of juvenile court that's left behind sometimes. My school has been wonderful about it, but we have to work together on it. With the providers, they come to the stakeholder meetings, and that's when I can present to them the issues we are having regarding their services. And of course, it's lack of funding. It's lack of funding. So it's not something that we come down hard on our providers. We work together to get funding so we can have these programs. But all of you are the ones that need to present to the court exactly the issues you are having. That's the only way the whole system, the big picture, can work properly. One thing you also need to know, let me go back. Multidisciplinary team training, very, very important. This is one of them. When I developed our drug court, they have some great programs on team building. That's a whole seminar in itself. I would suggest if you have any seminar on team building, you get your stakeholders in your district and your court together and attend. Now, we're smaller in Plaquemines. I know we can do a lot more than the larger districts because we do have a controlled number. We don't have 20 ADAs. We have one. Our PDO office and our attorneys are the 3 people. So we can do a lot more of this team building and stakeholder building. But I do believe it's very important that somehow in your district, I do know they have these meetings in Orleans Parish. Find out what's going on. Children and youth planning boards. Do any of you have that in your district? Raise your hand. Y'all do. So you don't know about them. Children and youth planning boards are very important. Jefferson has a great one, and Orleans does, and we do also. We have our meetings all together with our stakeholder meetings, but a children and youth planning board are planning for the service providers. They are there with the judges, the group of the whole community, working to have programs for the youth and families of your district. I always think it's important that you, the group who works with the service providers more than anybody, you have a wealth of knowledge. And I think it's very important that you convey that. I know I see some OCS workers and other people get very frustrated when they cannot get the services they want for their case. But these are ways, like I said, it's the big picture, that you can convey that to your district so that maybe some changes can take place in the future. Now this is, wait, I'm not running this right. Expectation number 2, and I've kind of talked about this. You need to know and have knowledge of the function, duties, and limits of each juvenile court stakeholder. Very important. You need to respect. Sometimes they are working on lower budgets, big caseload, and sometimes they are not really doing what they want to do because of lack of funds and just a caseload that's very large. One thing that I have seen happen, and this is my court employees, the people that work for me, know I will not accept. If I asked you to get me a report within 2 weeks, and I go to court, and you say, well, I called her at this agency, and I told her to get me a report. Where's the report? Well, I told her to give it to me. Well, did you follow up? Oh, one phone call. But it's her responsibility. She didn't give me the report. And this is what I call, you always have the ball in your court. Don't ever lose hold of that ball. When your supervisor, a judge will ask you to get something, don't pretend it's happening over here. And I just had to do this because I never do fun things with my presentations. I'm all kind of serious, but this is the ball that's going all over. I'm going to do it again. And my motto is always remember that ball is always on you. It never leaves you. That way you have control of the task that's been assigned to you. Very important. Now, I know what some of you are looking and saying, well, it's out of my control. I cannot have that report to you next court date. Document it. Have a timetable of when you called and who you talked to and exactly why there was a delay. That's important to me. That's important to the system, and that's important to all the stakeholders because we need to know where we just can't keep saying that they're booked, we don't have the services. We need to move forward and find ways to get funding and to get services so we do get our things better. Now, I can tell you, I have seen in my court that we have our young parents with addictive disorders, and we just do not have the proper treatment. We just started drug court. We have a few of them in there, which is wonderful. But in my court, it's not developed yet that if you did not commit a crime, you do not qualify for drug court. So I see I'm very concerned about some of our young parents who are getting to the system, and within 9 to 10 months of the case plan, they are having relapses because they're not in intensive outpatient treatment. So this is something that we're working as a team to try to early on have an assessment to put them in a program. But I must admit, some of these programs are not out there, or we can't get in for a few months. So these are issues that need to be addressed at your stakeholder meetings. Now, this is just kind of a boring part, but I do expect everybody to know the child welfare laws. I'm going to have to speed up a little bit. I do realize attorneys are going to understand the law a lot more than OCS workers or someone who's not an attorney, but you still need to be familiar with the law. It is so very important. And I'm not going to go through all the laws, but I did try to list for you all the different areas of the law, of course the Children's Code, that I think are very important. And I do have a list of websites that I'm sorry I was not able to put on the PowerPoint, but I'm going to leave a copy and have them copy and hand out. But there's a lot of websites that put a lot of these statutes and these acts and federal laws into a summary form that can really help out for you to understand. But in your free time, look over this. But it is a wealth of information. A lot of the federal acts have to do with funding, but it's something that I think everyone should know the big picture. And I think everyone should know the different laws that have been enacted and the new laws that are taking place. So that's an expectation that I have, that we get a lot of young people lately that have been in our system. And we learn from our more experienced one, and I have to point to her right there. Thank God that we have experienced attorneys in juvenile. We just set up our juvenile division in Plaquemines Parish. And I'm a new judge, the assistant district attorney was new, she never did handle juvenile. We have new attorneys for parents that are new, and we really have found that the attorneys that have been around for how many years, Margot? 24. It's very valuable. They are very valuable to your stakeholder. Go find them. You know who they are. You know who they are, and they have a wealth of knowledge, because you do learn on the job. Find that OCS worker. Find that attorney that's been around the juvenile justice system. They will assist you in so many ways. I have some wonderful juvenile court judges. Judge Conrad, Jansen, they have been wonderful as a young judge. Whenever I need some type of question answered, seek them out. Seek out that person that's been in the system if you're young. That's how you learn. I don't think I'm gonna have time. I was gonna go over some of these laws, but I don't think I will have time. A lot of these I'm sure you're familiar with, but it is important, and I do expect you to know the child welfare law. This is a very important expectation. Be a good witness. I have seen great witnesses, okay witnesses, and really poor witnesses. It's a very difficult job. I have some suggestions, but you need to remember that you are my fact finders. I need to know facts. And it's so frustrating when a witness is being questioned and they say, well, I think he was arrested last week, but I think there was some type of drug in his court, but I'm not sure because the probation officer didn't call me back. And I'm trying to decide if there's going to be unsupervised visitation for this person. You must be prepared. And everybody has their way to be prepared to know the facts. And I know sometimes the caseload is heavy, but you need to present to the judge facts that are clear, a clear timeline, not jumping around, and it needs to be presented to the court very clearly, okay? We read the case plans, I read everything. Maybe some judges have a heavy caseload too, but we do read it. We're prepared when we come to the bench. You need to be prepared. Sometimes I know it's a lot of information, and I can tell, we're asking, well, when did they call 6 weeks ago? But you need to have some type of timeline. Your files have got to be set up where you can open it up and tell the judge, because I rely on you. I make very serious decisions, and I take them very serious. I need to know and assess the situation to determine if I am going to approve the case plan, if I'm going to extend visitation, if I'm going to allow for unsupervised visitation. So it's very important that you become prepared. It's also very important that most of you do know the courtroom. You are very familiar with it. But sometimes I get witnesses, we have a terrible microphone system in Plaquemines Parish. And sometimes I know judges have said in conferences they can't always hear So just make a note of that you need to be heard and you need to look at the judge. A lot of times they look at the attorney, and I know that's difficult because the attorney's asking you questions, but try to present to me because I'm always trying to look and try to understand. And you always understand why you're being called to testify as a witness. And a lot of it is fact-finding. You need to tell me what happened in the last 30 days. You need to tell me why in the case plan this was chosen to do. Now, I know some judges may say that's too much information. I like information. We have long juvenile court dates. We left at 6 o'clock last night. But yes, but it's very important for me. And like I said, you need to know your judge. I like the most information possible. Now, you need to understand the role of lawyers, okay? You need to understand lawyers. Sometimes they're very different type of lawyers, so I don't want to stereotype, but we are very impatient at times. At times, if they are not as prepared to get the testimony that they want, they sometimes get frustrated. And sometimes on cross, I see some witnesses take it personally. You need to understand cross-examination is a fundamental right guaranteed by the Constitution and essential to due process. And cross-examination does not have to be cross. You just need to understand that is part of the system. When that attorney for the parents starts getting very upset with you because they were not informed of the proper program for their parent and the mother's failing now in her rehab, they're doing it because they're advocating for the mother and they're supposed to. When CASA comes and starts being very upset about the evaluation that has not been performed for 3 months, it's because they're doing their job, okay? That's how the system works. And I have seen witnesses get upset and taking it personally. But if you're prepared and you're presenting to the court the facts, because that's what I need, and you do it in a very clear manner, and if the facts are, I just wasn't able to do it because the infant center team is booked for 6 months, Judge, then we change the case plan. But that's what I need to know. I think OCS workers have the most difficult job. I just want to say that. I really, really do. You have the attorneys. All we're doing for you is getting that information. You're our main witness. The attorneys are there questioning you to get it out, making sure it comes out. But you are the ones who are providing us the facts so I can make my very important decisions. And this is just something that's important to me. When a child comes to my court, I want it to be the very positive experience in a very difficult time in this child's life. And what I have found is a good little checklist. A good little checklist to make sure when a child is going to be in my court, we make sure that we have arranged what type of arrangements we have made for the child, whether or not how the child will be transported, issues as to their school, whether or not how far the youth has been placed. Talk to a judge. If you know someone needs to drive from North Louisiana, ask the judge to take the case early so they can drive back. Do that. Remember I told you that minute clerk? You go talk to that minute clerk, okay? She tells me in which order. And we had it yesterday. We knew someone had to go back to North Louisiana, and we took them out of the order. Very important when you come here and you know that you have a child coming and we don't want them waiting outside. Be aggressive. Be aggressive and take control so that child does not have a terrible experience during a very difficult time. I also think it is very important that the judge knows if the child would like to speak to the judge. That's very important. I have been able to, I'm from a very small parish, so I see everybody, and they have talked to me about their experience in court. And they just said their little kids are so scared. They said when court date comes, they get stomach aches 2 days before, especially the ones that are in foster care. And it's a very difficult situation I think we all need to be aware of. They're in foster care, they are in a very difficult situation. Let's make their experience in court as positive as can be. Now, I know at our CASA Volunteers also brings pictures of the younger children if they're not in court. I think that's very positive. No, I like that. It brings reality to the judge. We get to see, a lot of times we talk about a child, and some of the younger ones, if they're placed out of state or if they're placed with a relative, I do not always get to see them. So I think that's a very important role that the CASA in our district has done. And it's very important that you submit reports to the court early. I have a huge docket. I'm a district court judge, especially district court judges. You remember, I have felony, I have petit jury, I have misdemeanor, I have arraignments, I have magistrates, I have family court. I need these reports as soon as possible so I can be prepared for the child. I like to know who I'm speaking to. And one thing that I have done, I always let the little ones come and use my gavel. If a judge maybe hasn't thought of that, ask them to do that. Hey, and I think you probably did it. Judge, can she come and to do the gavel? So, things like that, just to make the experience in court for the child one that is not so stressful, because they do get stressed. I hear it from their caretakers, and I also hear it from the court employees. So the checklist, just go through it. I think it's a very good tool. And I need to know if this, yesterday we had, it was delinquent cases, but we had 2 children that were extremely upset, and we had to bring them to Children's Hospital. This court brings out something. I had one Finn's kid said, "Judge, I'm just so stressed out when I come to court." And that's not what we want. So, just think of that. Think of ways that we can improve that. We can improve the environment in court for our children. Another expectation, you need to know your profession's practice standards. And that's good general, standards. Like, for instance, like I told you, I have the Judicial Code of Conduct. I read it all the time. Each day I learn something new as a judge, and I read my standards so I can keep staying at that level. Agency lawyers, the ABA has a practice standard. And they all basically are similar, but they basically, fully understand and comply with the laws. Promote timely hearings, reduce case continuances through timely pleadings and preparation. Attorneys need to promote and protect your agency's credibility. Very important. Cooperate, communicate regularly with other professionals. That's stakeholder cooperation. You need to talk to your client, agency about all legal matters related to individual cases. Keep them informed. Take reasonable steps to ensure the agency complies with court orders. That's very important, because you know what judges are doing now. They're bringing the department heads, your supervisors, and we are subpoenaing them into court. I think someone in Jefferson has done it, and so all the judges are hearing that it works. So just know that if I wanted a juvenile in OJJ facility, And I said, if she's not in within 7 to 14 days, it was 7 days, that you'll need to appear before me and tell me why. And you need to bring your supervisor. But she got in on the 5th day. But just, you know, we have to start on the bench putting demands on the agencies to make sure placement is there. And, you know, if there's not an opening, we understand that, but eventually we have to work together and make sure the services are provided. Now, I think Laura is representing the parents, and maybe because in Plaquemines we really did not have the attorneys for the parents. It was always, I don't think, it was done differently, but now parents are really need to be advocated for. I find our attorney for our parents in the district attorney's office gets into bickering fights, and they kind of, I find the DA's office always blames the parent attorney blames the system, and they both have points. And I'm listening to both of this because I have to decide, is it the parent's failure, or is it the system's failure? Or it's probably a little bit of both. But representing the parents mean that you have to advocate early on for proper assessments. If the assessment is wrong, the case plan is inaccurate and it will fail. And I tell the attorneys for the parents, you need to early on take control of that case plan and work with OCS. Work with them and tell me on the bench, when I asked, does anybody have any revisions to the case plan, any suggestions to me? That attorney for the parents should raise their hand and say, Judge, the case plan says that she's going to be in outpatient treatment. She should be in intensive outpatient treatment because she was on heroin. What if that is set? I mean, I believe that I would like to know that. I'd like to know that now, within the first, second month, not 9th month. When now she is relapsed because she was going to a group counseling at the local clinic and not an intensive outpatient or an inpatient. So that is something that stakeholders need to work together and talk. And I also see some CASA volunteers and attorneys for parents thinking their goals are different. And that's a big issue. I'd still say if everybody would work together on the same goal, that we would progress in the system. So anyway, I just feel for attorneys for parents also, because I know they get very frustrated because, you know, you kind of hear this is not going to work. You know, it's the parents' fault. They're not making their appointments. They're not doing this, and it's just an unfortunate situation at times. But here are the standards for lawyers. Of course, fully understand the law. Understand and protect parents' rights to information and decision-making while their child is in foster care. Avoid continuances and work to reduce delay in court proceedings, unless there is a benefit to your client for that. You should always cooperate and communicate orally and in writing in court proceedings on a regular basis with other professionals involved in the case. That's very important. As attorneys for parents, you need to advocate for the parents. You need to advocate your client's goal and empower the client to direct the representation and make informed decisions. It's very important that you have a duty of loyalty and confidentiality to your client. Communicate regularly with your client. Maintain some type of system of regular contact. That's very important. I mean, sometimes I notice that sometimes attorneys are just seeing their clients a day of court. And, that's a caseload issue, too. You talk to the PDO, and, right now they're working on having proper representation for parents, but it really is a tough job. And also be aware of your unique issues with missing parents and parents who are incarcerated. I've been seeing that a lot lately. So we've been working real hard in our district to make sure it's properly, we appoint an attorney and we properly try to locate, bringing in the parent from other detention centers in other states, other parishes. It can be very challenging. And also now, attorney for children. Of course, you have your special rules and you have your standard for representing the children. And I'm not going to go over all of these. But of course, one of the most important to me is requests for services. You see, I keep going back to service providers, that you really need to advocate for appropriate services to protect the child's interests and to formulate or implement a plan for services. And that includes any type of visitation, parenting education, housing. Attorneys for the children also, and I notice in my court, they also are working with the parents because their goal also is to rehabilitate the parents for reunification. So, and sometimes I see it stops because they get frustrated also with the parents and they need to advocate for the child. So it's a very interesting dynamics that's going on. But I personally think it kind of all falls back to the case plan and getting the services. So with that said, let's see, because I think I'm running out of time. Social workers, of course, you have your ethics for social workers and the Code of Ethics and National Association of Social Workers. And I just find a lot of the standards are similar. Service, dignity and worth, importance of relationships, integrity, competence, social justice. I feel that if we all look at our standards in our profession, that my expectations are basically part of the standards. Knowledge of the law, know your job, be prepared, protect the child, and very important, work with other agencies and other stakeholders. In every one of these standards, that's one of the one that echoes out in every publication. Now, this is something. This may sound silly to all of you because you probably know a lot about the juvenile justice system reforms, but there's still a lot of stakeholders I find that are not familiar with what has been happening, how the detention centers have changed, OJJ facilities or centers for youth. I think we all know they're moving away from detention to community-based treatment and rehabilitation and OJJ therapeutic centers for youth. I'm still getting people that I find are not as familiar with what is happening. A lot's happening. A lot of good things are happening. And I think it's important that you are familiar with your district. We are trying real hard in Plaquemines Parish. I set up a care center right after Katrina. It's something we were working on because we had lack of community-based services. And I went to a lot of seminars and they said that's where juvenile justice is going, that you need to get community-based services instead of detention. So we have been working, setting up counseling and services for our children and families throughout our parish. That's something you need to be familiar with. You need to know, you have to have your resource book. I know all of you do. But I can tell you, at least in Plaquemines Parish, everything changes. The Care Center, we develop new programs, co-parenting, active parenting. I can go on and on. We now have, our juvenile drug court. You need to be familiar with all the service providers and what's new in your district. And that's hard to do. especially in my parish, we had Katrina, we had the oil spill, we had an influx of services, and then sometimes they back off. So it's a constant change. So be familiar with what is going on in your district. Find that great resource book. It seems like every agency does it, but in Plaquemines, we have found some grant money where we're going to have all the agencies together, and we're going to continually have like a 3-ring binder resource book so we can insert new programs when things change, and when, counseling for domestic violence, when the time changes and the location changes. And in our parish, that's important because we're getting new buildings. We have our community centers being built in Buras, Port Suffolk, Boothville, and Davan. So we are constantly changing in Plaquemines Parish, and I think that's the same for Jefferson Orleans because we're still rebuilding. Just be familiar. Be familiar with some of the early intervention prevention programs to inform your clients. They need to know. Our juveniles need to know about the truancy. The parents need to know about the truancy laws. Help your clients understand what's going on, understand what their obligations are regarding sending their kids to school. Just very important. And something I do, and I know some other judges do it, I have programs in the school. I have Project Law where I go to 9th grade, and it's something I have done where I involve the behavioral health world. I involve OJJ, I involve Metropolitan Human Service District. See what your district's doing. Get involved in some of these programs that's good stakeholder to build respect, to build coordination, to build cooperation. That's one reason I set up Project Law, because I do bring all my stakeholders into this, and it's a fun day. We're not in court looking at the most difficult cases. We're in the schools where there's happy faces. The kids love a PowerPoint. They love when the council comes talk about issues of dating. So it's a time for my stakeholders to get out into the community, and we work together on a very good cause. And I find it brings a lot of mutual respect and cooperation. Now this is to end it, because I wanted to leave some time for questions. This is my, from the bench, the top 10 list. Top 10 list of things to avoid. Number 10, thinking that you must know everything, even though I just told you must know everything. But I don't think, we know that's not practical. Thinking that you know everything, avoid that. Thinking that you are the only one who has the best interest of the child or family in mind. We all do. Number 7, misunderstanding your own role in court. Very important. Number 6, not being prepared. Number 7, not respecting the role of others in the proceedings, including the court. Number 4, not communicating and not being available. Got to answer those phones. Have to answer the phones. I hate when someone gets up there and says, this person never answered my calls, or why is the report being faxed in while we're in the middle of the case? You got to communicate. Assuming that standards are different or lower in these proceedings. Sometimes because it's juvenile court and sometimes I feel that they think it's a little more informal, at least in my district court, because before I took the bench, juvenile day was kind of like a stepchild of the district court, and it's something that we've worked with in our district because we only had one day for juvenile court, and right there you're against the rules. So we've changed that around to know that we have our own juvenile division now. Judge Connor and I restructured the 25th Judicial District Court last year, and we have Division A, Division B, which is our district court duties, but we have juvenile division. And I handle all of juvenile division. He handles adult drug court. So it kind of makes our proceedings not just part of the district court. And I think it's been very valuable for respecting the system now. Number 2, losing sight of why the court is involved in the business of protecting children and strengthening families. And finally, number 1, the most serious error of all is not caring. And I know all of you here do care, but sometimes you got to watch burnout. You have to be very careful of just getting frustrated. And I have really found when you start reaching that level, start finding other people and express your frustrations. You need to express it to, I tell everybody to talk to me, and we're pretty open in our court. A little bit too much sometimes, but that's what I want. I want to hear your frustrations, because you always want to care and know that we're here to protect the children. Okay, anybody needs to speak to me, here's my contact information. And if you have any questions, like I said, I am a judge who feels like she learns every day. I learn from you. If anybody here has, issues that I was talking about, any suggestions that you would like to say to a judge that you don't always get a chance to. Yes, ma'am.
Question, I'm pretty new to Louisiana, clear about 8 months from Wisconsin. I worked in domestic violence for about 15 years. My question is here, in regards to the juvenile offenders of domestic violence, how is that, is there programming to work with those juveniles in regards to that?
For juvenile domestic violence offenders?
Yes.
Repeat the question on the mic so you can.
The question is, when you have a juvenile that is being charged with domestic violence,
Right.
what we have done, now in adults we have the Duluth method. I'm just saying what we have in Plaquemines. Our adult offenders go to a 26-week class. For children, what we have done is just put them through the care center, do an assessment of the whole family, and usually do individual counseling, not group. I have not seen a specific program just for juvenile offenders.
Yes.
What we have done in Plaquemines, when I was in the Assistant District Attorney's Office, I am a strong believer of early intervention and education. I set up a 5th grade program called Project LEAD, and I know they have it in Jefferson, I think they have it in Orleans now. We've been having it, I set it up 10 years ago, and 2 of my classes are on domestic violence for 5th graders. And it's basically anger management, discussing issues. Now in 9th grade for Project Law, we have a counselor come in and talk to them about dating violence. I go through the law and let them understand that if domestic abuse, battery. So I do believe in that. And I think that's something very important, early intervention in high school, and discuss these issues. And to get reporting. If they know that we have, one reason I set up the care center also, because they know it's for domestic violence victims on top of many other things. It's a center it's a family justice center, a child advocacy center, it's many things. But they know that we advocate for that. So it becomes an awareness in the community that, you know what? And I set up no drop policy. They know if there's domestic violence in Plaquemines Parish, your case is not going to be dropped by the victim coming in and signing a drop affidavit. And it works. It works beautiful when you look at the big picture. But I think programs in the school about dating violence is so very important. And the teachers have said they have seen changes in kids. I have a PowerPoint where I show them what your sentence will be if you do hit your girlfriend. I believe it's important. But for counseling, I see that individual counseling works. And it's usually a cycle in the family, so I always bring in the whole family. I evaluate the whole family because, sometimes the dad is abusing the mom and the child sees it. So, I think of working with the whole, to break the cycle. That should be our goal. So I allow a child to speak, but I do allow the attorney's parents to come in. I will always have the attorney's parents, but I may not have the parents, because you know why. Because, I want to hear from the child, especially I find in divorce cases when a child is being pulled between a mother and father, if either of them are in there, they just will not speak the truth. But if I have the attorney for the child and the attorney for the parents, I feel they're well represented, and I allow that. The Supreme Court has a wonderful program, and I'm going to get you that website, because they have a lady at the Supreme Court Judicial Administration Office who summarizes every child welfare case. She does a wonderful job, and she has a book for us. It's just wonderful. It's Child in Need of Care Proceedings, and it's on a website. Yes.
It's www.clarola.org.
And that's where Corinne's book is good. There's a lot of information out there. And also the Louisiana Council for Juvenile and Family Court Judges, I believe they have a website also. I think they're developing it. I'm not sure if it's up yet. But they were planning to use it also as a tool to keep stakeholders in juvenile court informed. So definitely that's something that is important. Anything else? All right, well, thank you very much. I enjoyed it.
Welcome back. For a good portion of the remainder of the day, you're going to be hearing from Nell Flanagan, Family Services Program Manager at DCFS, Linda Rainey, Foster Care Program Manager, and Christy Tate, Foster Care Program Manager from DCFS. And I cannot stress how vitally important this portion of the training is. I wish I had counted, but during Judge Librano's presentation, did you notice how many times she mentioned case plan or case planning? So we feel it's very important, especially for the attorneys who are in the audience who may not think that this is applicable to them, to service providers, to everyone, all the stakeholders that are involved, to thoroughly understand child welfare policy and processes and the linkages between those processes and then the goals that we actually have for the parents and the families that we work with. A good deal of their time is going to focus on safety and risk assessments, and you will have the opportunity to see demonstrations of those tools that are now being used by DCFS. So at this time, I'm going to turn things over to Nell Flanagan. You will have time, and there will be a slide that specifically says questions. Please hold your questions until that time. Be sure to speak loudly, and then Nell, if you'll remember to repeat those questions on the microphone for us. Oh, we're going to start with Linda. I'm sorry, my apologies. We're going to start with Linda Rainey, and I'll let you go ahead and take the podium. Thank you for coming.
Good morning. I'm glad to be here at this CASA training. Foster care has such a big challenge before it. We in child welfare have a lot upon us, as the judge said earlier. There are many things that we're responsible for. And our agency in 2000, probably really before Katrina, they started to look at changes that would help us to more effectively work with families. And after Katrina, we had the National Resource Center here. They provided technical support in terms of case planning. They looked at our youth in transition program. We came up with a lot of different strategies to engage our youth and to provide for more better outcomes for them. Gary Mellon has provided numerous supports to the agency. We've utilized the technical assistance that has been provided to us. We're trying to make our agency better, reduce the number of children who come into care, and if they do come into care, hopefully children can return home faster, because we all know that children hopefully can do better in their own home. Sometimes it's not possible, it's not feasible, but that's a challenge that we face every day, because when you break the connection with family, something is lost. This is the Safety Form 5 that we utilize, and it begins initially in CPI. Safety is assessed at the initiation of the investigation, and it should be reviewed throughout the life of the case. The Form 5 is a national form that we've been utilizing. There are 14 safety factors that are looked at, and we'll look at that a little bit later. This is the safety assessment that is utilized. There are 14 questions. Would you all like to look at it a little bit, and then we can talk about it? These are the areas, the safety factors that we're looking at when we're called into an investigation. And if any of these safety factors are endorsed, we must develop a safety measure to address those safety factors. I'm sorry, I can't see, I'm blind. Oh, they're too short too? Okay. So the safety assessment is done on each child that's in the home, and we look at the caretaker's behavior. Is it violent or is it out of control? We have to support each factor that we address, and we make a response in terms of what that answer is. The caretaker describes or acts toward the child in a predominantly negative terms or has extremely unrealistic expectations for the child. The caretaker has caused or has made plausible threats that have or would result in serious physical harm to the child. 4, caretaker refuses access to the child or the child's whereabouts are unknown and cannot be ascertained, and there is reason to believe that the family may flee with the child. 5, the caretaker has not or will not provide sufficient supervision to protect the child from potentially serious harm. The caretaker has not or is unable to meet the child's immediate needs for food, clothing, shelter, and/or medical care. The caretaker or other person having access to the home previously harmed a child, and severity of the harm or the caretaker's prior response to the incident suggests that the child's safety is an immediate concern. 8, child is fearful or in danger from the caretaker or other family members or other people in or having access to the home or the facility. 9, the child's physical living conditions are hazardous and may cause serious harm. 10, child sexual abuse is suspected and circumstances suggest that the child's safety may be at an immediate concern. 11, the caretaker's drug or alcohol use seriously affects his or her ability to supervise, to protect, or care for the child. Domestic violence present in the home or facility places the child at imminent risk of danger or moderate to severe harm, and the caretaker's explanation for injury or harm is unconvincing, and they may deny the injury or harm or any other significant safety factors that may apply. The safety, if the safety factors are endorsed, each one has to be, we have to make a plan to address that. And the final decision, if no safety factors are endorsed, we would say that the child is safe, and there would be no mitigating circumstances or things put in place to address safety. If the child is unsafe, we have to make a plan. Either we look within the family to see if there are any supports. We decide with the caregiver, in collaboration with them, who will do it, when will they do it, for how long will they do it, and the length of time that this safety measure is in place. If we cannot safely make a safety plan, we may ask for custody of the child, and that would be the safety plan for the child. With the safety plan, it must be reviewed ongoing. If a child comes into custody and the safety plan is done, when it's assigned to either FS or foster care, there needs to be a review of that safety plan. And as long as the child is in custody, the safety plan has to be reviewed on an ongoing basis, especially when the goal of reunification is there and you're going to place this child back into the home. You have to ensure that those safety factors have been remediated. Okay. All right. Neil is going to talk about the structured decision-making model right now.
Okay, thank you. This is part of the assessments that the worker completes on the family. As part of the series, they start out with the safety assessment, then they do a complete risk assessment, assessment of family functioning, and then move on to a case plan. They're all tied and interrelated, and I hope you see that throughout the presentation. The assessment of risk that we use is the structured decision-making model, and it's designed to help child welfare workers in their decisions at critical points throughout the life of a case. And after the initial risk assessment is completed, the worker's going to know if the family before them is more likely or less likely to have an incident of repeat maltreatment over the next 2 years if the agency doesn't provide any services. It doesn't predict repeat maltreatment. It just says this family is at very high risk for having another incident. And it's much like the
medical questionnaires you might have completed if you're more likely to have a heart attack or diabetes. It doesn't predict, but it is comparing your answers to those who have had that condition. And that's much like the tool that we're using for our families. The Children's Research Center looked at up to 200 factors that were associated with repeat maltreatment and narrowed it down to 17 that were most highly correlated with having that maltreatment recurrence. And that's what we have on our form. And how could that information be helpful if you know as a worker this family is at low risk for repeat maltreatment or very high risk for repeat maltreatment? What can you do with that? For one, it's going to affect your approach and how you respond to this family. Going back to our medical analogy, you and your doctor are going to have a very different response if you're at very high risk. You might be put on a special exercise routine, diet, bring out the medication, but if you're at low risk for those conditions, they're not going to pull out all those resources. Same thing with our families. If they're at low risk, we're not going to put them in the IHBS, the intensive home-based services, and therapy and parenting classes. But if they're at very high risk, we're going to tailor those services to meet their needs. Okay, Children's Research Center is a division of the National Council on Crime and Delinquency, and they were created in the early 90s specifically to help child welfare agencies reduce child abuse and neglect. And we're not the only ones who are using this. It's in 30 jurisdictions, at least right now at this time, and each one has shown a reduction in maltreatment that's substantiations, injuries, and reentries into foster care, as well as expedited permanency. Some states have used it in the entire state, like we went statewide with ours, but some have just chosen to use it in certain counties. And in those, it was very interesting, the research, when those counties had no additional funding, just implemented these tools, there was a drastic difference in the repeat maltreatment rates compared to those that did not use these tools. Okay, it's an evidence-based approach, and it assists our workers from CPI to FS in foster care make decisions at critical events from the very beginning with investigations. There's a decision tree that we just implemented for a response priority. So the worker's going to find out, okay, does this meet the definition of abuse and neglect, which hasn't changed? If so, what's the response? Is it going to be an investigation or alternate response family assessment? And from there, what's the time frame that we need to respond? Is it within 24 hours or do we have up to 5 days? In family services, it informs the visitation between the worker and the family, how frequently they'll go out, and it also lets us know when it's time to close a case. And foster care, the same as well. It informs when it's time to close or change the permanency goal from reunification to possibly another alternate plan for the child. Promotes the principles of reliability, validity, equity, and utility. These tools promote consistent decision-making. When they're used, the workers come to a consensus as to what the risk level is for this family. There's inter-rater reliability. When they studied other tools, they didn't have that agreement. When workers looked at a case, some might have said it was moderate, some might have said it was high, very high, no consistency. And that's important because for the family, it shouldn't matter what worker they get or what parish they go to. There should be consistency among the type of services they received based on their situation. For validity, it measures what it purports to measure. When we say that this family is at low risk, they are not likely to come back to the attention of the agency. If they're at very high risk, they are very likely to come back if we do not open services on them. Wasn't the case in other tools that were studied. The other tools gave a risk level, but it didn't correlate to what eventually happened with that family. There was very little distinction between the moderate risk or high risk family as far as our repeat maltreatment rates. Equity, it was fair among ethnicities and socioeconomic levels. It didn't discriminate in any way. And utility, it's very easy to use. The tool itself, we're going to have a demonstration of it. It's point and click from the multiple choice questions. And the information is very valuable. As far as targeting agency resources, in our example earlier, when we throw out more services targeted to that family when they're at high risk, as opposed to the low risk families that may benefit from a referral to one of our community resource providers. And in a time of budget cuts, we need to prioritize what services we provide to the families. Okay. Initially, CPI is going to complete this, but once it's referred for ongoing services, if that's found to be necessary, that ongoing worker, either family services or foster care, is going to conduct a reassessment every 3 months. The different rating levels are low, moderate, high, and very high. And it also decides, I mentioned the intensity of services. Low-risk family means the worker has to go out once a month. These are minimum standards. Of course, they can go out more frequently. Moderate is twice a month. High, 3 times a month. Very high-risk families receive 4 visits a month. That's very different from before. Before, it was once a month, regardless of the risk level. That was our standard. So we talk about caseload, but this is also workload as well. That's a lot more time spent with the family, a lot more going out for and meeting with the clients. Very, very different. The tool's not going to take the place of the worker, though. The research informed the tool, and then that tool is going to help inform the worker's decision. It's not taking the place, though. The worker's clinical judgment is going to be key in this. Okay. When the worker completes the tool and sees that it's at low or moderate risk, the presumptive decision is going to be to close that case. If it's at high or very high risk, the decision would be to refer it for ongoing agency services. When I say close, it doesn't mean the family doesn't receive any services, just not from the agency. That would be one of our community partners, like a resource center, for example. For any of these, if there's an unresolved safety issue, it automatically is referred for ongoing services. Doesn't matter what the risk level is. What stood out most for staff when they received this presentation was that it didn't matter about the validity. You can have a very high-risk case with an invalid finding. It's still going to be referred for ongoing services because the repeat maltreatment wasn't related to validity, but the factors that you're going to see. Does anybody have any questions about that? Okay. As far as targeting resources, they found in their research that families that were rated as low or moderate risk came back to the attention of the agency at the same rate whether or not their case was opened by the agency for ongoing services. It was drastically different for the families that were rated high or very high. When we opened a case on them, and I say we, that was the state where they did this research, it wasn't here. When they opened a case on the families that were rated high or very high, the repeat maltreatment dropped by about half. Significant differences. So we want to target our money and services, resources to the families that are at very high risk, since we're going to have the biggest impact right there. And the tools are only as good as the information that's being put into them, of course. And it does take time. You can't just go with the family and read these items to them and answer the question. There's engagement, there's open-ended questions, and that's a different skill set. And it was difficult for some of our CPI workers to adjust to that, since they were used to that fast-paced rush, let me get in and investigate this allegation at hand. Very different. They have to learn how to engage, learn some interviewing skills. The example with the timeout, if they just go and ask the family, because one of the questions is about discipline, if it's excessive. And they could ask, so what do you do when little Johnny, who's 3 years old, gets in trouble, disobeys, maybe he's throwing their toys, and the parent says, oh, well, I use timeout. And the worker's really happy to hear that because that's 3 minutes in the corner. But if they take the next step, oh, tell me what that looks like, and you find out it's in the corner for 30 minutes, kneeling on rice, arms out, very different picture. And so we're having them spend more time with the families, engage, and that's going to be the theme, I think, of the century is engagement, which is not just for this assessment, but the assessment of family functioning. It's all levels, all workers. And engagement, it's more than just the family having a say-so or input. It's really about motivating them, empowering them, shoring up their resources and relatives so they can sustain this change. When using the tool, workers must use the definitions. It keeps us consistent, and from using our own definition of, or our own thinking of what that question might be getting at. We're going to see when you, on the tool itself, there's a little button you can click and it pops up the definition, so we're all clear as to how we're answering it. After we answer the risk assessment tools, there's an opportunity for an override. There are mandatory overrides, and these situations represent very serious, usually rare situations, though, that warrant a very high-risk rating. So you might have come up with your other items with a final risk assessment of moderate, but if one of these mandatory situations exists, it's going to bump it up to very high automatically. And that's like death of a child, non-accidental injury, substance-exposed newborn, and we're going to see some of those. The discretionary overrides, where the worker judgment comes in, that's where they have information about the family that the tool just didn't capture. And it's not going to capture all the nuances that our families have. So the worker is able to raise the risk level up one. On subsequent assessments, they can go up one level or down a level. But since this is at the very beginning, still getting to know the family, they either keep the risk level the same or can increase only one level. Okay, this is where the worker goes to complete it. The top information is just basic demographic information. We've got name, tips, parish. As the questions, now remember when we're answering these are the ones that they found are associated with families who have had repeat maltreatment. What is the current report for? Abuse, neglect, or both? And as I score it, on the right over here, it's automatically keeping track of the rating for me. So I don't have to worry about that till the very end. It's going to tell me what the risk is. Have they had prior investigations? If they have, it raises risk. Okay. Not only have they had prior investigations, but have they had an open case with the agency, family services, or foster care? Number of child victims involved. The more children, the higher the risk. Prior injury, age of youngest child, under 2 is higher risk. And I'm just randomly scoring these right now so we can get a risk level at the bottom. Characteristics of the children in the household. Okay, the caregiver's assessment of the incident. If they're blaming the child, that's going to raise the risk. Do they provide physical care consistent with each child's needs? See, all of these aren't clear cut. You won't just know until you have a conversation with the family on how to answer these questions. Okay, caregiver and some characteristics of the caregiver. They have a mental health problem. And these are the definitions, those little boxes with the question mark. If I click on that, that's going to clarify for the worker what that means. Let me pop it open. There. And all of these questions, this assessment, it's a household-based assessment, so I'm answering it for the people in that household. If mom and dad are together in the household, I'm going to assess which one is the primary caregiver and which one is the secondary caregiver and answer the questions accordingly. If mom and dad are in separate households, they're each going to be the primary caregiver in their own household and will each receive a risk assessment. So here's a question, R13 is about the secondary caregiver. Now that might not be dad, maybe that's a household where mom lives with her mom, and grandma provides some care to the child. I'm going to rate grandma as a secondary caregiver. Here's another question. Primary caregiver has a history of abuse or neglect as a child. If I didn't read that definition and use my own interpretation, I might think, well, I did an agency check and I don't see any history, so I'm going to say no. But if I read the definition, it says credible statements by the primary caregiver or others that indicate that the primary caregiver was abused or neglected as a child. So just the credible statement of that caregiver is enough to endorse that answer. Okay, 2 or more incidents of domestic violence. And some of these look familiar. Some of these you saw on the safety assessment that Linda went over. But the difference here is that this is for risk, hers was safety, an immediate situation. This, we're looking at the likelihood of future events. Okay, when I score, let me move this. Okay, it's telling me the risk level is high. At an initial, I can first look to see if any mandatory overrides exist. If they do, it's very high. I think it's tiny. Can y'all see that? I'll read some of them. The mandatory override, sexual abuse, and the perpetrator is likely to have access to the child. Non-accidental injury to a child under 2. Severe non-accidental injury, that would be for any age. Caregiver action or inaction resulting in the death of a child due to abuse or neglect, and birth of a child during the review period, and the mother or newborn had a positive tox screen, alcohol or drugs. If those don't exist, then I have the opportunity for a discretionary override, so I can make it very high if I have additional information, or I can just keep it at that level. Also in the initial, we have extra questions that aren't factored into the original score. This is just part of research to see if in Louisiana these issues are related to repeat maltreatment. And that's criminal history, the number of moves, and the number of live-in partners that the parent might have had. And this afternoon, we'll take a look at the reassessments. And Linda's going to talk to you about the difference between safety and risk.
What's the difference between safety and risk? Safety is current or impending danger, and risk is the potential for future harm. A safety factor is generally also a risk factor, but a risk factor is not necessarily a safety factor at the time. Safety or risk are both. This is going to look at the substance abuse issue. Okay. This is the scenario. This is, there's an allegation regarding lack of supervision of a 6-year-old who was found playing near a busy road at the front of the neighborhood today after school. Caller says mom is a drinker. Mom admits to drinking but states she only drinks at night after her daughter goes to bed. Mom states that she was gardening in the backyard and thought her daughter was playing right there. She turned around and saw that the gate was open and her daughter wasn't in the yard. She has been calling neighbors and wondering about calling for her. She states that this has never happened before. So is this safety or is it risk? I didn't hear you. Is it safety or is it risk? Both? Look, there is no indication that the mother is under the influence at this time. While the mother admits to having difficulties getting up some mornings after drinking the night before, the father is the person who gets the child up for school and packs her lunch every day. So there, in this situation, there's a mitigating person in the home who can make sure or ensure the safety of the child. Is that clear? Huh?
It's not home.
And I think the challenge is when our staff are out there, they're constantly having to review the safety and the risk. Is it safety or is it risk? Because we may not have the complete picture in order to make a determination about safety and risk.
So which is it?
It's risk because the child could, this child did get it, but they said at night, if she's home and dad is the person who gets up in the morning and ensures that she goes to school. If mom was there by herself and the child wandered off and there was no one else there, it could have been a freak accident. I don't know. But if mom is there and she's supposed to be providing the supervision and something happens, and because of her substance abuse issues, something happens to the child, it becomes a safety factor that we have to look at and address. Questions? The next scenario is domestic violence. The report alleges that the parents fight often and aggressively. There are 2 kids in the home, ages 12 and 15. The neighbors have reported hearing lots of yelling and things breaking, and that this is not uncommon. Last night, after an argument, the father took off on his motorcycle and the mother was chasing him down the street, throwing beer bottles at him and cursing. Caller does not know if the children were at home. So is it safety or is it risk? Both. The parents admit to fighting and they get physical, but they say they don't throw things or get into it when the kids are around. If they think things are heating up, they send the kids to their uncle's home for the night. They say that while they don't always get along with each other, they know enough not to fight in front of the kids. But the children are still exposed to what? Domestic violence. So it's a risk factor. Safety and a risk, mental health. Robert alleges that a 10-year-old came home to school today, upset over mother's deteriorating condition. The mother reportedly hasn't gotten out of bed for the last week, except to go to the bathroom and occasionally eat some food or drink, some water that the daughter brings to her. The child reports that they are out of the house, out of food in the home now. 10-year-old. And the child goes on to say in the explanation that the child says that the last time that something like this happened, her mother took a bunch of pills because she was so sad and had to go to the hospital for a long time. And the child had to go live with her aunt for the summer. I think this shows us the importance of the ongoing need to look at safety and risk factors, not only for our children. For some of our children who enter foster care, sometimes all of the children in the home may not enter custody. So therefore, the worker is charged with ensuring the ongoing safety of those children who remain home. And our goal is to get children home, if we can, with parents cooperating and reducing the safety and risk factors for the children. So we use these tools in order to help us not to be biased, but to ensure that there are plans in place to help our families and protect our children. Before we go to the questions, Initially, when I started, the PowerPoint didn't pick up but you all have it on your point. We were talking about the challenges that our agency is facing and the rollout. We began the rollout with the Focus on 4 in 2007. It's been because we're constantly going back and doing things in order to help improve what our agency does and provide tools to our staff that will help them to discharge their duties and responsibility. In 2008, there was statewide training. We changed our philosophy. We talked about engaging parents. We involved stakeholders because we want our families, if they can, to take responsibility for rearing their children. We want to keep maltreatment down if possible. And now we had our CFSR last year, and we're in the process of developing our program improvement plan. And there were 3 highlights of the plan that we as an agency need to address. We need to enhance the capacity of families to safely provide for their children's needs so children can stay home if possible. We need to enhance timely and appropriate permanency planning. Permanency is so important for each child who comes into care because the length of time for a child can seem forever. And we only have 12 to 15 months to work with families. So we have to do the best job that we can engaging them. Sometimes if mother is not the appropriate parent and if she comes to a decision, maybe the father can be considered as a resource. Or if reunification is not at all possible, maybe transfer of custody to a relative. Adoption is usually considered the most permanent plan. However, we need to look at those connections that our children have and how important those connections are. Last year, when we did the permanency and transitions, it was really a good practical effort that we used because we talked about the need for our kids to have those connections. We can't allow kids to grow up and exit the system with no contacts. Imagine if it were you or I and we had no one to lean on, no one to call back, no one to call and say, oh, how are you today? So we all know in our own lives how important connections are. And so we have to pass this on. That's why it's important. We also engage our children that we work with. We need to talk with them. Who were the important people in their lives? What happened if your mom was sick? Who came to take care of you? And it's not always, we know families are different now. It may not always be the paternal or the maternal relatives. It may be the friend down the street, or it may be someone else that person has a relationship with. And relationships are worth keeping if we can maintain them. So we have some lofty goals, and our staff are going to be working really hard to achieve these goals because we need to satisfy the program improvement plan for the feds. And we've had so many things that have impacted what our staff do. The educational stability for children. We know that children do better if they're stable. We know they do better if they have constant visitation and contact with parents, if it's viable. So these are the checkers or the checkpoints that help us to gauge how our children are doing. We need to reach for an absence of maltreatment recurrence, absence of child abuse and neglect in foster care, not only in foster homes but also in facilities. We need to increase quality family visits. We need to increase placement stability, decrease the percentage of children remaining in foster care for long periods, and decrease the percentage of children exiting to adulthood without a permanent plan. When children come into care, after those initial assessments are done, our staff have 30 days in order to complete. So we have to begin engaging that parent early on. We have to do a case plan, which is required by federal law within 30 days. And the parent has to be a part of that case plan. We can't develop a plan for the parent without her input because she's not going to buy into it. So it's really important. And staff can do a really good job of engaging our families. Families do better if there's engagement from the initial onset of the case. We know sometimes it's difficult because we may have hostile people that we're working with, but we need to validate the anger that they may feel. We need to validate that that their children are separated from them at this point. But we also need to develop a case plan that will help them to work toward reunifying with their children. The agency has encountered a lot of challenges. We have staff turnover, fewer staff. A lot of people come, and because child welfare is challenging, maybe they decide that this is not the job for me. I think our training unit does a really good job of providing not only the initial overall training for our staff, but there are intermittent trainings also. We need supervisors and districts to help support our staff who come. We need them to know that they're not in it alone. We need to work and reach out to our stakeholders, our CASAs, our attorneys, our judges, because it takes the whole community, not just the worker. Our caseloads have increased because of the expectation. The SDM, if it's a high or very high rating, that means that our staff have to have more contact with our families. And the more contact we have, hopefully this will be purposeful contacts, and we can work with families on developing and identifying what their needs are and talking about their capacities to parent. The learning curve. We've had to go back and provide some additional supports in terms of the SDM, and we've refined it. Well, when Deidre O'Connor and Rick came down, it's really a good process. They continue to provide support to us. Each region is going to have a peer support person who will be able to provide the extra support that our staff will need in terms of looking at, and the agency is attempting to provide consistency throughout all of our regions, because what you get here in New Orleans or Jefferson, the same type of services should be available in North Louisiana. And we also know that sometimes the transportation, because of placements, is a big barrier if you don't have the appropriate placements where children live. And if kids can remain in their own communities, it's much better. It's easier to get home. And the other big challenge we have is reorganization. And our reorganization is continuing. We're one Department of Children and Family Services now. There has been some reorganization with all of our parish and regional offices. They know more or less who's going to be where. There's still some, the organizational chart for state office has not been completed at this time. We know that there will be field operations and child welfare. So there will be two different components, and the expectations will be probably a little bit different. Our job will still be to provide support to the staff here. Our primary responsibilities are the assessment of safety, assessing risk, assessing family functioning, case planning, and assessing progress. So that's why we want our staff to have the tools, the supervision, and the support that they need in order to take this charge. So that's why we use the SDM, the Form 5, and the assessment of family functioning. So one thing I wanted to tell you all about family engagement. Family engagement involves building an alliance with the family. In other words, the family believes that you are there to help them. Their input is crucial and their voice matters. We must allow families to know that we are transparent. They must know how our decisions are made and how plans are made in conjunction with them, not without their input and commitment to working to reduce and to eliminate the barriers that led the child to being placed in agency custody. To do this, we must start from a point of strength and see the protective capacities that parents have. When families are engaged, the net gain is client success. And hopefully we will see permanency for children, the stability of placement, and fewer reentries into care. Families simply become more successful. There have been several research studies indicating that clients who achieve significantly more case plan goals and objectives are more successful when workers initially engage the family. Some of the studies reveal that clients were more likely to follow through on referrals when they were engaged by their worker. In 2002, a study indicated that 77% of the families followed through as opposed to 35% when the family was not engaged with the worker. In Minnesota, research has shown correlations between the quality of family engagement and child safety as measured by decreased maltreatment. because when children go home, it's the family, the parents who have to protect them. Illinois' research has shown a correlation between the quality of relationship between the resource families and the birth families. And we have some foster parents who really do a really good job of being able to accept parents and work with them. They help, some of them can help make our jobs a lot easier. The other big factor is the impact of consistent family visitation. If there's consistent family visitation, children tend to go home sooner. That's why in the reassessment we have to look at we usually begin with supervised visitation, but the assessment can direct us as to when we're going to be able to do visits without supervision. And the parent knows her child better than we do. What are the child's likes? What are their dislikes? Helping families to decide how their visits can work. And we've utilized visit coaching. Visit coaching began in New York, and they have an empowerment. They have empowered some of their clients who've worked with our agency before, and they are models for other parents who come into contact with the system to help them to understand how to work within the system. We must take time to make engagement and partnership the cornerstone of our practice, which can result in more expedited and extensive goals of reunification. The benefits of family engagement are: it enhances the helping relationship, it promotes family buy-in, it expands options for our children, it improves the quality and the focus of visits, it increases placement stability, it improves the timeliness of permanency decisions, it builds family decision-making skills, problem-solving strategies, and lastly, it enhances the fit between what the family's needs and services are. Any questions? Thank you.